service providers, advocates, district attorneys, anyone who kind of calls with legal issues that they want to discuss. We also do trainings, provide information and referrals, and also consultations on criminal cases for victims who maybe don't need a direct representation, but maybe just need some extra support or education about the criminal process.
And my name is Cassie Houston. I'm the program manager for the Legal Information Network of Colorado. LINC is one of the programs within Rocky Mountain Victim Law Center. It's a federally funded demonstration project that's a collaboration of different community groups working together to improve legal information and resources for crime victims in Denver. So we do a lot of connecting people with information about all kinds of legal issues, both civil and criminal, through a website that's listed on here, coloradolink.org, also our helpline, and a network of specially trained navigators who help connect victims to the legal information and the resources they need. And we are going to be kicking off a whole bunch of navigator training in the next month or two, and we'll certainly be sending things out about that. So if you are in the Denver area, LINC is Denver-based right now, not statewide like all of RMVLC. Definitely keep your eyes open for additional trainings on that. As we go forward today, like Jody mentioned, we're going to talk about the civil criminal system, the criminal legal system, the civil legal system, and the Victim Rights Act. But we're going to do it from a really kind of 100-foot view of looking at just the larger concepts, what the major differences are between the different systems, and what that means, how they interact with each other, and issues that are specifically of importance to victims. So definitely looking at things from a broader viewpoint, not dealing with really specific legal questions. I know in looking through your registrations that there was a lot of great questions that you all submitted, and we will try and answer as many of those as we can as we go along. But really you're going to be looking not at specific cases you might have dealt with, but just a general overview of the legal processes. The other part of that is this is just informational, so this isn't going to, this will give you just general information more about how the legal process works, so you can share that with the people you work with without worrying about unauthorized practice of law or giving legal advice. It's really just having a better understanding of what the legal system is, what all the different parts are, and how that works together. There is also a chat box. If you have questions, we will try and answer them. If we can address them while we're presenting, we will. Otherwise, if we have time at the end, we will try and answer some of them at that point. We will also give you our contact information if you have email questions at the end. So we're going to start today to just try and get an overview of where everyone's at by doing some quick polls on different legal issues to, sorry, I'm clicking at the same time, to just ask you what your initial feeling is based on today before we do the training about what kind of areas of law different things are. So I just opened the first one about what area of law is a lawsuit in a car accident. And if you could just go ahead and click on what you think the answer is. I see a lot of answers coming in. That's great. Okay, so I'm going to go ahead and close that out. Most of you have voted. And most of you did say that it is a civil area of law, which is absolutely right. Some people said both. A car accident could be both if it was related to a ticket or something about that, negligence on the criminal side, and actually the crime of being in the accident, fleeing the scene, or things like that. But in terms of just filing a lawsuit against someone for damages, injuries, damages to your car, injuries to your body, harm, pain, and suffering, things like that, that is a civil legal issue. Let me go into the next one.
So the next poll question is, what area of law is an arraignment of a defendant? And so we'll open that up for your answers and give you a few seconds here to get your answers in. Seems people are getting things in really quickly. That's awesome. So it looks like most everyone has gotten their answer in, so we're going to go ahead and close the poll and share those results, and 79% of you said criminal, which is absolutely correct. So an arraignment is the stage of the criminal justice process where the defendant is going to either plead guilty and accept some sort of plea offer and go to sentencing, or plead not guilty, and the case would then set for trial. So that is absolutely in the criminal system. And oftentimes, just kind of as a side note, defendants will have more than one arraignment. Often they will be continued for a variety of reasons, to consider plea offers, to do some more investigation and things of that nature. So it's usually not a one-time only thing. There's often several arraignments that happen in a criminal case.
Okay, the next one we're doing is, what is a verdict in a case? Is that criminal, civil, neither, or both? You guys are fast and accurate. Okay, so I'm going to go ahead and close this one. So 75% of you did say that it was both, which is true. So a verdict can be what happens at the end of a civil case if it goes in front of a trial. It can also be what happens at the end of a criminal case. And we'll talk a little bit more about that in other areas of the law where it is very similar in both the civil and the criminal side.
So the next question is, what area of law is a U visa application? And so we'll go ahead and open that up for your answers. All right, awesome. So it looks like there was a little bit of a split here between civil and neither. And so immigration issues are actually more of an administrative law function. It's less on the civil side. It has its own processes, its own different courts, and so we'll talk about that a little bit as well, and how that also interplays with the other systems that we're discussing today.
Okay, two more. So another one is, what area of law is a Title IX complaint against a university? I'll go ahead and close this because it looks like most of you have voted. And again, this is another one where there was a pretty even split between different things. So civil, neither, both, criminal. So this one's a little more complex. Title IX is a pseudo-administrative process. So it's kind of like a civil legal process, but it is generally internal for just doing a complaint. As a victim, if you file a Title IX complaint, it's administrative within the university and within the federal regulations that oversee that. But it could also relate to a criminal case, or it could also turn into a civil case if it involves a lawsuit against the university for a larger issue. So it's a little bit of everything. So you're kind of all right on that one.
All right, last question. So what area of law is a protection order? So we're going to open that up for your answers. Y'all are really fast.
Okay.
All right, so we're going to close that out, and once again, there's a pretty even split across both and civil, and then a small percentage of criminal. So this is actually the starting point of the presentation, where we're going to talk about protection orders, because there are actually protection orders in both criminal cases and civil cases. So they can really be either. So everyone that said both, great job. So like we said, they could be either. They could. There's a mandatory protection order in criminal cases, which I'm going to talk about a little bit, and then Kazi's going to talk to you about permanent protection orders, which is a civil issue. So they're both obtained through different processes. They last for different durations, and but a violation of either is a crime. So we'll go ahead and start talking about the mandatory protection order and what that process looks like. So the parties in a mandatory protection order, the restrained party is going to be the defendant in a criminal case, and the protected party is going to be the named victim in a criminal case. And it's a little different than a civil protection order, because the victim doesn't go to court to request this protection order. When a crime's been committed and there's charges filed, the court actually issues the mandatory protection order. And that lasts through the duration of the criminal case, and that includes the sentence. So if you have a 25-year sentence, that protection order lasts through the entire sentence. It doesn't just end after the trial or after there is a conviction. If charges are dismissed, though, however, that mandatory protection order goes away, which is kind of the end of a sentence or a dismissal of charges or a not guilty verdict kind of pulls in the civil protection order in a way that Kazi is going to talk about a little bit.
So a civil protection order is often what advocates interact with more in terms of going to court with a victim, helping them file a civil protection order. So it's a little different in some basic ways. One is that the parties are not the defendant in the criminal case and the victim. It's actually a petitioner and a respondent. So in this case, the petitioner is the victim who's seeking the protection order against the respondent instead of a defendant, since it's a civil action. And the petitioner actually has to go into court and request the civil protection order on their own. It's not something the court does for them. It can be done outside of a criminal case. It's completely separate from any criminal case process and isn't something that prosecutors or anyone or the court just automatically puts in place. So generally the process is that a victim has to go in and file a request for a temporary protection order, fill out a petition with a lot of forms that explain incidents that have happened. And what the court is looking for initially is that the victim is in imminent danger. And that's the legal standard that the judge will look at to decide if they can grant a temporary protection order for 2 weeks to begin with. And if the judge looks at all the facts and everything that's happened and makes that finding of imminent danger, they'll enter the temporary protection order for 2 weeks and set a hearing for 2 weeks later at a permanent protection order hearing where the respondent will be served with the temporary order, usually by the sheriff's department, and then they have to appear at that second hearing to either say they object to it, they don't object to it, or try and agree to extend it for up to a year, or if the respondent doesn't show up at all, a permanent protection order should be automatically entered. That's called a default judgment, getting heavy into the law. And then the big difference also with civil protection orders over the mandatory protection orders in the criminal case is that they do last forever if neither of the parties tries to dismiss it. So once a court, and it's on the civil side, decides there should be a permanent protection order in place, and to do that what they're looking for is that all the facts that the victim brought up in the temporary protection order were true and that there's a danger of ongoing harm if there isn't a protection order. So if they enter that, it stays in place forever until one of the parties dismisses it. And what that usually looks like is either the petitioner decides they don't need it and goes to court and asks to have it dismissed, or in less regular cases, the respondent, after a set period of time, which I think is currently 3 years, and sorry I did not check that again right before I came in here, is they can petition the court to have it dismissed also, but then there will be a hearing, the victim's involved in that, and it generally will be another court decision to see if it's okay to have it dismissed if the respondent wants to do that. It's not that common for it to be dismissed. Once a permanent protection order is in place on the civil side, it generally stays in place. The other big difference between civil protection orders and mandatory protection orders is that it can include lots of extra provisions. So a mandatory protection order can't add a lot of extra things about who gets to have pets and safety of pets. Civil protection orders can include that. They can also address who can live in the residence. If it was 2 people living in one residence, the respondent can be essentially removed from the house through the civil protection order process and not allowed to be there. It can also order the payment of some ongoing bills like rent, utilities, insurance, things like that. And it can also, through the civil protection order, award temporary care and control of children to one of the parties and set up kind of an interim visitation schedule just to maintain the safety of everyone involved. And those are all provisions that are only available in the civil protection order side. However, I did want to make a note that even though, like Jody mentioned, a violation of civil or criminal protection order is a separate criminal offense and is against the law, if someone violates the provisions about housing and pets and payment of bills, that's a civil offense, so it's not a criminal charge. So you can't call the police and say, I have a protection order, this person's supposed to be paying the rent and they're not paying, go arrest them, because that's a civil portion of the order, so that's not actually a criminal offense.
And something really important to note here is that a victim could have both a mandatory protection order and a permanent protection order in place at the same time. Like Kazi just said, the permanent protection order provides provisions that the mandatory protection order doesn't. So often we will see people who have both in place, or people who wait until the mandatory protection order ends and then go file for a permanent protection order. So there's a number of ways that that can be done, but you can have both at the same time.
And we did have in the registration a couple questions that I can circle back to now. One was how best to prepare clients for permanent protection orders, especially when the respondent has counsel. So my recommendation for that would be to try and connect them to a legal advocate that's really familiar with the process, or ideally an attorney. So maybe through Colorado Legal Services, the law schools sometimes have clinics that have students that can help with that, other organizations. But if a petitioner can't find an attorney or get assistance, it's really just preparing for the case like it's a hearing and making sure that they have a list of the dates of all the incidents that they're talking about where they were in imminent danger, and then trying to match some evidence to that. So if it related to punching a hole in the wall, bringing a picture of the hole in the wall or things like that. Text messages, printing them out, emails and voicemails, having them on a, either printed out or on a separate recording that can be left with the court. So generally that's my suggestion if there isn't an attorney or an advocate available to help, just having people go through and collect different evidence related to each thing, and also preparing them that they are going to be talking about what happened, and also being able to ask the respondent what happened, and the respondent can also ask them questions. So it can be a little bit of a nerve-wracking process, separate from a criminal process, because there isn't a prosecutor there to speak on behalf of the victim in those cases. A lot of times they are doing it on their own, and it can be challenging. The other question that we got was how to make sure court orders are enforced, and if it is a violation of the safety and the contact parts of the protection order, whether it's civil or criminal, that would be just a call to law enforcement and trying to address it through that process. But for the other civil issues like the payment of bills, pets, care and control of the children, it generally involves going back to the court through a contempt process to try and request that the order be enforced on that level. So hopefully that answers those questions.
So now we're going to talk a little bit about the criminal legal system. And as Cassie mentioned earlier, this is kind of a 100-foot view. I'm not going to get into the nitty-gritty kind of real legal aspects of it, but please feel free to ask questions if you have any, and I'll try to answer your questions that you submitted through registration as we go along. I may skip over a few at times, but it's because we're going to answer them a little bit later. So first, when we start talking about the criminal legal system, we need to look at who the parties are. So the parties are the people of the state of Colorado, which is represented by the district attorney. Then you have the defendant, who is the person who's accused of committing the crime. Something really important to note here is that the victim is not a party to a criminal case, which is something I think that we see a lot of that people don't really understand. So the victim is often treated, and we'll talk about this later, more as kind of a piece of evidence or a witness, but they aren't actually a party to the case. And so as I mentioned earlier, the district attorney represents the people of the state of Colorado. And with that, that means that they do not represent the victim. So the district attorney may have their own ideas about how the case should be prosecuted and their own obligations that don't necessarily involve the victim and may not potentially take into account the victim's wants or needs in the situation. So that's kind of where we're going to talk about the district attorney's discretion, which is another area that we see a lot of questions and confusion about. So the district attorney has discretion with filing decisions, and what that means is that the district attorney gets to decide whether or not charges are going to be filed in a case and what those charges are going to be. Now, they do need to consult with the victim and let them know that these charges are going to be filed, but the victim does not have a way to file charges on their own. I think we often hear people say, I pressed charges against him, or I'm dropping the charges against him. We often hear people who have been victimized say things like that, and that's not exactly true. The district attorney is actually the one who has the discretion on the charging decisions, and that means they can choose to file charges, or they can choose to dismiss the charges or never file charges. And often we see that conflicting, obviously, with what victims want. Victims often feel very strongly that charges should be filed in a case. However, the district attorney has certain ethical obligations in their charging decisions and filing charges. And what that means is that they have the ethical obligation to only go forward on cases where they feel like they have a reasonable likelihood of conviction at trial on. And that gets into a whole lot of evidentiary reasons that we won't talk about right now, but it's something that people are often upset about and confused about and don't understand that them just calling the police or them reporting a crime isn't actually the charges being filed, that the district attorney gets to make that decision. And that also, this district attorney discretion also comes in with plea decisions. So the district attorney has the duty to consult with a victim regarding any plea offers that they're considering making. And we'll talk a little bit more about the victim's role in that in a minute. But it's ultimately up to the district attorney what plea they offer, what the length of the sentence that they're offering, what charges that they're going to go forward with for the plea. That's the district attorney's decision. The victim has the consultation right, but ultimately, once again, that is up to the district attorney. So in all of this, we talk about the district attorney representing the people of the state of Colorado, not the victim. The defendant is represented by a defense attorney. So who represents the victim? And the answer, unfortunately, in most cases is nobody. The victim doesn't have their own representation, as much as us here at RMVLC would wish that all victims in criminal cases, all victims of violent crime had their own representation, because we believe it's vitally important. In most cases, victims don't actually have their own representation. So we talked a little bit about the DA's ethical responsibility, and that also plays into the burden of proof. And Kazi's going to talk a little bit about the burden of proof in civil cases, and there's an important distinction there. And so it's important to know that in a criminal case, the burden of proof is proof beyond a reasonable doubt. And what that means is that every element of a crime must be proven beyond a reasonable doubt. And reasonable doubt doesn't mean space aliens came down and committed the crime. That's not reasonable doubt. But it is a much higher burden of proof than you have in the civil system, and it's something that people don't often understand, especially people who may have gone through a civil case and then they come into the criminal system. They don't understand the differences in those burdens of proof. So just know that it is a higher burden of proof, and that it's proof beyond a reasonable doubt. So we've already talked about the district attorney participating, the defendant and the defense attorneys participating in the criminal justice process. If you go through trial, you're also going to have a jury. They will call witnesses at different stages. There's motions hearings that will need witnesses. The trial stage, there would be witnesses. And of those witnesses, the victim is often one of them. Once again, though, the victim is not a party. And then you obviously have the judge who presides over the entire process. Sometimes courts are split a little different, and there's different judges for different aspects, but there will be a judge who presides over motions and trial and things of that nature. So if you go through trial and the jury deliberates and comes back with their verdict, like we talked about earlier, there's two options that can there's a couple of options that can happen, but we're going to talk about a guilty verdict versus a not guilty verdict. So if a guilty verdict happens, then the case will proceed to sentencing, and that is where a victim has the right to give a victim impact statement that talks about how the crime has affected their life and the impact that the crime has had on them emotionally, financially, physically. Really, it's kind of an open field what the victim can talk about. And we'll talk about those a little bit more when we get to the victim's role in the criminal justice process. So if there's a guilty verdict, the case will proceed to sentencing. If there's a not guilty verdict, then there is no sentencing. The case is done at that point. The victim can't appeal that not guilty verdict. So the defendant will leave court, and that mandatory protection order will also go away. So like we talked about earlier, that mandatory protection order is going to, if there's a guilty verdict, last through the pendency of the case and through the sentence. If there's a not guilty verdict, that mandatory protection order goes away, which is often a time where it's vitally important that the victim learn about resources and get resources on a permanent protection order. So now we're going to talk a little bit about the victim's role in the criminal justice system. Like I already said, victims have often been treated as pieces of evidence, and what that means is the victim is brought into court to give their testimony, to talk about what happened, but they're not a party. They don't have a very well-defined role in the criminal justice process. And so that's historically what that's historically kind of has been the victim's role. Now in Colorado, we have a very robust Victims' Rights Act that tries to give more meaning to a victim's role in the criminal justice process and tries to help a victim be heard through this process, but still they're not a party to the case. And that often leads to a lot of confusion in the process and a lot of kind of pain and hurt through the process of feeling like evidence, feeling like nobody cares about what they have to say and their role, and really can kind of hurt sometimes relationships between district attorneys' offices and victims, because it's very difficult to explain this horrible thing has happened to you, but you're not actually a party to the case, and the defendant has all of these rights, and you have rights too, but oftentimes defendants' rights are treated as more important, and we'll talk later about why that's not the case, that they are not more important. So going back to the victim consultation, when a district attorney is going to offer a plea to a defendant, the district attorney has the obligation to consult with the victim about that plea. And it is our very strong belief that that consultation needs to be a meaningful consultation. It shouldn't just be a message left on an answering machine or a quick call, this is what we're doing, okay, talk to you later, goodbye, or a quick, this is what we're doing right before you walk into court. It should be a conversation, because the victim should get to feel heard and get to feel like their voice mattered. Now, unfortunately, what that consultation does not mean, it does not mean that the victim gets a veto. So they have a voice in the process, but they don't get to veto the district attorney's decision. And that goes back to the DA's discretion in deciding what pleas to offer. And that's something that often leads to a lot of confusion, because victims hear that they have the right to consultation about the plea offered, and oftentimes assume that that means that they get to change it if they don't like it, or if they tell the judge they don't like it, the judge will change it for them. And that's not the case. They get to have a consultation and they get a voice about that, and if they disagree with the plea that's being offered, they can tell the judge that, but they can't change the plea. They can't file something on their own that changes the plea, and they don't get that option, unfortunately. So like we already talked about, if the victim does disagree with the plea, they can obviously tell the DA's office. We often here at the Rocky Mountain Victim Law Center will do some advocating to district attorneys' offices about pleas, and talk about maybe what could be done differently, or what could help the victim feel like they've been heard and feel like the outcome is in their favor. And they can also, they have the absolute right to be heard on that issue in front of the judge, and can tell the judge that they disagree with the plea. So I know we had a question about roles of different people within the system, with the role of the district attorney, the role of a district attorney's office advocate, or a private lawyer. And that can be really confusing, especially when you're talking about privilege. So we're going to kind of try to unpack that a little bit here. So I think we already talked about the district attorney's office, the district attorney's role pretty well. They represent the people of the state of Colorado. They are the ones that will present evidence at trial. They are prosecuting the case. They have the discretion in charging and filing charges, dismissals, plea offers. So something that a lot of people don't understand, and I think that is missed a lot of times in that education piece, is that anything a victim says to a prosecutor or to the victim advocate at the DA's office could potentially be turned over to the defense. The DAs have the obligation to turn over exculpatory information to the defense. And so exculpatory means something that shows that the defendant is not guilty, or more likely to be not guilty. And so if the district attorney's office comes into information that they consider exculpatory, they have the ethical obligation to turn that over to the defense. And oftentimes how we see that play out is a victim who calls their advocate at the DA's office, not a community advocate, or who calls the DA themselves and talks about therapy that they're receiving or mental health diagnoses that they've gotten. So if that happens, and the DA feels that that's exculpatory information, and oftentimes district attorneys' offices take very broad views of exculpatory information to protect their own ethical obligations, they may have to turn that information over to the defense, which is obviously not what we want to protect victims' privacy. So the DA's office advocate does not have privilege with the victim. They are required ethically to turn over any exculpatory information. So if a victim calls and gives them information that they consider exculpatory, they will have to turn that over to the defense. And that's not to say that victims shouldn't talk to DA's offices or DA's office advocates. It's a super important role, and they need to have those strong relationships as cases go through, because the DA's office is who's going to prosecute the case, who's going to have to question them if they have to take the stand and testify. So those roles are vitally important, and they need to have a great relationship. But it's often, especially for community advocates, very important to explain the difference in that privilege role, and that as a community-based advocate, I do have advocate privilege with you, but the district attorney's office doesn't. So if you have information that you feel like you want to share, maybe talking to a community-based advocate would be safer in sharing that information, because I would not have to, as a community-based advocate, not have to turn that information over. And usually DA's offices do great jobs of explaining that, but it's incredibly confusing for a victim who's, one, in trauma, is going through this process oftentimes for the first time, has never seen anything about the legal system beyond law and order. And when you hear the word advocate, you think, oh, well, this person's here to represent me. And unfortunately, that's not the case with the district attorney's office, as we talked about earlier. So that distinction is very, very important, in that the DA's office advocates and the DA's office themselves don't have privilege with a victim like a community-based advocate would, or a private attorney. So as a victim's attorney, I have privilege with the victim, and I would not give over any information, obviously, to the defense that the victim gives me. So there's always a conversation that needs to be had when you're working with victims around that issue, and around who actually has privilege and who may be the best person to share certain information with. Obviously, we want, victims to feel empowered and feel like they can talk about their situation and talk about what they've been through with who they want to. But it's also doing a victim a disservice if we're not explaining that in depth, because we don't want private information turned over to defense attorneys that could then be used against the victim on the stand. I think that hopefully answers the question that was asked. Obviously, if you have additional questions, please feel free to ask. I'm really happy to talk about this subject a little bit more. But right now we're going to move on and talk about victim impact statements, which is a super important role for a victim. So impact statements are given prior to the judge deciding a sentence. And they can be given even if there was a plea deal taken and the defendant just pled guilty, or if you go through trial. And they can be given in several different ways. It can be a written letter that's just given to the judge, or a written letter that the district attorney or another family member or an advocate reads to the court. The victim can come in, they can give a written letter and then come in and give their own oral statement to the court. There's a wide variety of things that can be done. One of the most important things about the impact statement, however, is that the victim has to talk to the court. They can't address the defendant as much as victims often want to be able to do so. The defendant will be in court and hear that impact statement, but they can't address the defendant directly. They have to address the court. And the importance of the impact statement is twofold, really. Well, three or fourfold. There's a lot of important reasons for impact statements, but some of the most important are that it really gives the judge a sense of the victim's experience. And oftentimes is the first time the victim, through the whole process, has been able to tell the court their real experience. Not just testimony about the events and what happened, but their real psychological, physical, financial, emotional, their real experience with this crime and what this crime did to them. So that's often, important for victims therapeutically, but also it's important that the court know those experiences prior to deciding a sentence. Oftentimes we see judges in giving a sentence who reference the victim impact statement and reference the things that the victim has gone through and say that that's a reason that they're giving a larger sentence or going on the higher range of the sentencing range. So they're very important to help judges understand really what the victim's going through and has gone through and will continue to go through because of the defendant's behavior. And also, like I said, important for the victim to feel heard, because often that is their first time to be heard on that issue and to really get to say what they want. So victim impact statements are vitally important, I feel, and something we do a lot of here is helping people write those, and I think that it's always great to have an extra pair of eyes or set of eyes when victims are going through writing that process, because it's such an emotional experience and oftentimes bringing things up that maybe have never been brought up before. So briefly we'll talk a little bit about the outcome of a criminal case. We've talked about sentencing, and often sentencing can be a variety of different things. The defendant could be sentenced to a term of years in the Department of Corrections, sentenced to county jail, sentenced to community corrections, probation, sometimes a state mental hospital in cases where you have not guilty by reason of insanity. So there's kind of a wide variety of options in sentencing that we won't go too deep into, but just know, I think a lot of times people expect, oh, this person's going to go to prison for the length of their sentence, and sometimes that's not true. Sometimes they never go to prison and they just get probation. So there's a wide variety of sentence options that defendants, can end up with, and that's often super important to be able to explain to victims. And then also restitution. So restitution can be kind of an interesting issue. I think we always recommend that victims should ask for everything that was a cause of the defendant's behavior. We often feel that victims should ask for. We've had victims ask for civil attorney's fees because of protection order issues that they had to get because of the defendant, and when. So, oftentimes restitution will include victim compensation being paid back, medical expenses, sometimes therapy expenses, and sometimes, not, and maybe like housing expenses if a car is damaged, if not housing like rent, but if a house has been damaged, property damage, things like that. But you can always think about out-of-the-box suggestions too. If something has, if the victim has incurred an expense because of the defendant's criminal behavior, it's something to consider looking at for restitution, and something that we're happy to always talk about, with anybody who has restitution questions, because that's kind of the victim's chance to at least be partially made whole financially in the criminal system. And so I know Kazi's going to talk about the civil system and how a victim could be made whole through the civil system, but restitution is the victim's opportunity to try to get some sort of financial compensation for what's happened to them. And it's not compensation for pain or suffering, but for actual expenses that the victims incurred because of the defendant's behavior.
Okay, thanks, Jody. So now we're going to move on to talking a little bit about the civil legal system, and again, that kind of 100-foot view of just generally what that involves, what that means, and how that is different from the criminal system. A lot of times when we get calls that come into our office, either through the BRA side of RMVLC or through Link, one of the first questions we need to find out when people say, I have a court date coming up or I have a case, is what kind of a case is it? Is it a civil case? Is it a criminal case? Are there more than one case pending? And a lot of times it's just helping people piece that out for themselves. So there's definite value as advocates in knowing what those different systems look like, what kind of cases fall into which system, primarily so you can ask those questions to help make sure you're directing people to the right kind of information, the right resources, and things like that. So unlike the criminal system, which was really just anything involving a crime, where if the police are called or there's a crime committed, which is a little more straightforward and easy to understand, the civil legal system includes almost everything else. So it generally involves issues between people. So it can be family law cases, divorce, custody, adoption, things like that. It can be what's called probate cases, so wills and estates, trusts, and also if you have a person who's at risk or elderly, it might be a conservatorship or guardianship proceeding to decide someone else can be appointed to be responsible for their finances and other decision making. That's also handled through the probate court, which is also civil. It can also be a contract dispute, so between different people, between businesses and organizations, things just very basically about you promised to fix my garage and my garage door and you didn't do it, so now I'm going to sue you because you violated the contract. That's a civil legal issue also. Collections cases are civil, as are evictions. So if someone's being evicted from housing, it's often through specific courts that are allocated or dedicated to handling housing cases and evictions. Same thing with collections. Those often end up in small claims court, but that still falls under this giant umbrella of civil. Employment law cases around discrimination or things like that are also generally civil cases, or just things about wages, back pay, things like that. There are some employment law cases that fall under administrative law, which is more about discrimination if the government is bringing a discrimination case, or workers' compensation. Those are administrative law, but general things like you owe me back pay, I didn't get my benefits, or wrongful termination, things like that fall also under the civil legal system umbrella. Another whole area of law under civil legal systems is intellectual property. That's things around patents and trademarks. So there's actually a lot of litigation that happens around that in state and federal court around use of trademark names, names of businesses, patents, protecting things that people have developed. And it's a whole separate area of law that attorneys actually have to pass a separate bar in order to practice in that area of law, but still falls under the civil legal system. And then the bigger one that is probably, with the exception of family law court, the one that is most relevant for victims is often tort law. So a tort is basically a harm to another person or their property or their reputation. So car accident cases are tort laws. If you bring a civil case related to property damage, that can be a tort. Defamation and slander about damage to reputation, that all falls under torts. So it's just harms to other people is what tort law is considered. So one thing to, and this might not be an exhaustive list, it's everyone that Jody and I could think of, but there are a lot of other areas of law that just kind of find themselves under civil legal issues separate from the criminal side. But just to give you an idea of the breadth of that, because these are so many specialized areas of law, and we'll also talk briefly about some of the things that don't really fit well in civil or criminal, it's also important to find attorneys that do practice in each area of law. So there really isn't such thing as just a general practice attorney anymore because the legal system has become so complex. So if someone practices criminal law, they really might not have any experience in the civil legal system, which has its own set of rules, its own rules of evidence, its own way of doing everything. And then within the civil system, if someone is a divorce attorney and does an outstanding job with that, they very likely know nothing about employment law or intellectual property or vice versa. You know, someone might be doing a little family law, a little probate, but generally if you have clients and victims you're working with that are trying to find an attorney for a specific area of law, it's really trying to find attorneys who practice in that area of law, which is also partly why we broke this list down for you so that you have an idea of what to search for. They can go to places like the Bar Association's Find a Lawyer page and pick different areas of law. And finding an attorney that specializes in these things is important because each of these little subsets within the civil legal system can be incredibly complicated and needs someone that has a lot of expertise in each of the areas of law. So in a civil case, it's not a defendant, it's except sometimes. So in tort cases, sometimes it's still referred to as a defendant, but instead of it being the prosecution and the people of the state of Colorado versus John Doe, it's, you know, Mary Jane versus Don Doe. So it's a petitioner or a plaintiff versus a respondent or a defendant. So it's actually one person bringing a case against another person. There is no government agency that's stepping in to take the place or automatically represent someone. And parties in civil cases often proceed pro se, which means without an attorney. So it's not uncommon at all in civil cases, especially things like civil protection orders, family law cases, small claims cases, things like that, for someone to just go to court without an attorney, and they don't have a right to have one appointed in that kind of a case, and they can access a lot of resources to help them through that process, but often they are just going on their own into court trying to make something right in their life and trying to get things corrected. So that's similar to how before the criminal system evolved to having a prosecutor, it used to be that victims would just go into court and address their criminal issues only, but that's changed on the criminal side but not on the civil side. So on the civil side, there is no automatic attorney representation, there's no prosecutor, and that role is just missing from the process, which is, you know, no value good or bad about that. It's just one of the big differences between criminal or civil. In a civil case, the outcome of a case can be decided by a judge, but is very often decided by settlement. So it can be done by a judge or a jury, but the jury is a smaller number. So in a criminal case, juries are 12 people usually, and in a civil case there might only be 6 with alternates assigned. And there's also a difference in the burden of proof of what a jury has to decide, like Jody mentioned. And that is, in a civil case, it's generally that a case has to be proven by a preponderance of evidence, which means just a little more likely than not that it happened. So unlike in a criminal case where the burden of proof is to prove every element of a crime beyond a reasonable doubt, in a civil case, the person bringing the case, so the petitioner or the plaintiff, is the person that has the obligation to prove that whatever happened just was more likely that it happened than it didn't. And that, you know, that could be 50.1%. It's just a little tiny bit more like a feather on the scale. It's really not nearly as challenging as meeting the beyond a reasonable doubt preponderance and burden of proof that's in criminal cases. So for that reason, a lot of times people who have been through a criminal process, if the criminal case hasn't proceeded or charges weren't filed or they didn't like the outcome or a defendant was found not guilty, or even if they were found guilty, they can also bring a civil case on the same set of facts, and it might be easier to prove that with the burden of proof. And that's the kind of thing we often hear about in the media, where you'll hear about something that sounds like a criminal act, but then it's actually a civil case that's related to it, because it's just a different standard to prove in a civil court than in a criminal court, and it's just easier for people to do that. The outcome, I'm jumping around a little bit, so sorry about that. The remedy and outcome of a civil case is different than a criminal case because it can't send someone to jail, it can't send someone to community corrections or probation. It's generally money. The civil cases generally are around money or injunctive relief. So when it says on their damages, that means money. And if a plaintiff or a petitioner can show that they lost a certain amount of economic damages, like someone didn't fulfill a contract so they were out $2,000, then they might get $2,000 awarded, so it's damages. Injunctive relief would be around things like I want them to stop doing something. So civil protection orders, no contact, orders not to publish information, things like that are more around injunctive relief, and there's not necessarily any money attached to that. Sometimes people just go to court in the civil side to just request that something stop. So someone can't do something or needs to stop doing something that they are doing. So those are the two remedies of civil cases, which is probably one of the biggest differences from the criminal side, is that the outcome is just different. But people do talk about it in terms of, like Jody said, of being made whole, of using the civil legal system to try and correct something that's happened in their life, to make a wrong right and make them whole, returning them to the place they were before that thing happened. So if the criminal legal system can't do that, oftentimes there is a way to access those kind of remedies in the civil system. The other thing I did mention a little bit was that there is a different set of rules and timelines, and rules about sharing information, rules about when things are filed, how you get information, and it varies between not only the civil and criminal system, but each kind of case. So family law cases, divorce and custody cases have their own set of rules in the kind of law books and the statutes about when you need to file things, when you can ask for information from the other side, what kind of things you have to ask for, what you have to give other people, when things go to court, things like that. And then in other kinds of civil cases, it's a whole separate but similar set of rules about the same thing. And some of those can be as picky as how many written questions can you send to another party to ask about what happened in a situation. So if you sue someone for a car accident, each party can send a set number of written questions saying, do you know about this on this day, or also things saying, I need you to produce these certain records. But there's a very set limit on when that can be done and how many can be done. So there is a lot of very specific rules, which goes back to that need to find an attorney that practices in each area of law, because they are specific to each kind.
And now, just to throw a further wrench in all of the processes, there are other legal proceedings that don't necessarily neatly fit into a criminal proceeding or a civil proceeding, and then can also overlap with criminal and civil legal processes. So we talked a little bit earlier about administrative law, and that deals with things like benefit appeals, Medicaid, Social Security disability, workers' compensation, public land hearings. Title IX is kind of that quasi-administrative proceeding that Kazi just talked about. And Title IX proceeding is often something that you will see with a concurrent criminal case running, or happens pretty around the same time as a criminal case. And Kazi will talk to you kind of about the interplay between the civil and criminal system here in just a minute, so I won't go into that. But there is often a concurrent criminal case and Title IX case. You also have bankruptcy, which is its own animal. There's separate bankruptcy court, separate rules, separate everything. We won't talk too much about that because that's not really the scope of what we're doing today, but we did just want you to know too, if you are trying to help a victim who is looking for a very specific attorney, these are kind of the terms you can use to look up a different attorney or try to find someone who specializes in these individual areas, because they all have their own rules, sets of procedures and things like that that just kind of a general attorney may not know. Also immigration. I know we talked about the U visa a little bit, and that's kind of an interplay between immigration law and the criminal system. There's the criminal component of the U visa application, but immigration is also its own separate area that you would definitely want to try to find somebody who practices specifically in immigration to help with immigration issues, because like I said before, there's a whole different set of procedures and rules, and you want to make sure that you have somebody who can really practices in that area to get the best outcome for the victims. Lastly, there's military proceedings, and there's even more proceedings than we're even talking about right now. But military proceedings is often something that we see happen with a concurrent criminal aspect. So sometimes you will have a civilian court, not a civil court, a civilian court prosecute, or civilian jurisdiction prosecute a military member for criminal behavior. And so with that prosecution, while it's prosecuted by the district attorney in a civilian setting, there may also be concurrent military proceedings that are going on to punish the military member through the military. So it's often something that's confusing, and especially when you have two different kind of jurisdictions battling for who's going to prosecute the case. So it's definitely something that if you have questions about, trying to find somebody who specializes in the military aspect, maybe your best bet, just so that the victim can understand the differences between a case being prosecuted by a civilian jurisdiction or a military jurisdiction, and what could happen if there is the civilian prosecution going on, what could happen to the military member through the military. So I think that that's probably all we're going to get into on those areas, just to kind of keep it a little bit more simple. But if you do have questions, please let us know. And just, I know through Link, Kazi can probably provide referrals for these resources. As my part for the Victims' Rights Act kind of program that I take care of here at the Rocky Mountain Victim Law Center, I don't practice in those areas, but we are always happy to try to help find resources and referrals and kind of put our heads together about what we can best do to help victims if you are seeing questions in these areas.
And part of the reason we wanted to go through all these different areas of law is the section that we're going to talk about next, and that's how the different cases intersect. So it's possible that a sexual assault victim could have a criminal case pending, they could have a civil case where they are seeking a civil protection order, or there might be custody issues or things like that related to it with the same person involved. They might have a civil case that's a tort that they filed a lawsuit against the person, the respondent or defendant. They could also have a Title IX case happening at the same time, and potentially if one of the people was in the military, there might be a military case pending. So a single incident could result in 4 or 5 different cases that are all related and tied together. So that's one reason why we wanted to make sure we spend a little time highlighting how these cases do intersect, because there are so many different areas of law and so many different standards of proof in the way that you do discovery to get information from the other side and how information is shared, that it's important for advocates and victims to understand that that information can be shared across cases. So if there's 3 or 4 different cases going on in different areas and different courts and on slightly different things but all generally involving the same people, any of the testimony and evidence that's brought in any one of the case can then be brought in as evidence into any of the other cases. It's not automatic, but if there is a criminal case, they could try and request information from a civil case, a Title IX proceeding, a military proceeding, and then have that evidence go through usual rules of evidence to try and be admitted into the criminal case. One of the biggest examples that we often see with that is with civil protection orders while a criminal case is pending. So it's often in a victim's best interest to go get a civil protection order while there's a criminal case, just in case that mandatory protection order were to go away, if charges weren't filed or the case resolved itself or a sentence was served, things like that. But the timing of that can be important also, because if someone files a civil protection order and they, in their petition to do that, write out a whole bunch of set of facts, and it happens to be the same facts that are part of the criminal case, then the criminal defense attorney can get that same information, and if there's any inconsistencies in the stories or if there's anything left out in the civil protection order, it might show up in criminal court by the person saying, well, you didn't say this happened 2 months ago, but now you're saying that this did happen, and it just can expose victims to raising issues about credibility. When we know that trauma and a lot of other reasons lead to inconsistencies in statements, but just helping people understand the importance of when you go fill out this form for a civil protection order, you also need to be thinking about what impact that could have on all these other types of cases. So one of the examples that advocates talk about sometimes in that area is the checklist that some jurisdictions require for incidents in a civil protection order. So if you're in a jurisdiction where the court wants victims to fill out an incident checklist and basically check the box of all the different kinds of abuse that could have possibly occurred, if they were to leave something off of that that is then at issue in the criminal case, the criminal defense attorney can very easily say, well, on this one form you said all of these things happened, but you said that there was no physical abuse or there was no sexual assault related to this, but now you're saying that there was, which is it? And it just makes it more challenging for victims to have to navigate the process when they have their own credibility being questioned and trying to make it a little easier. So one way around that is to just make sure people understand that, and because like Jody talked about, any information that enters a criminal case does also go to the defendant, even if a prosecutor is the one that's informed of, I also brought a civil protection order, here's a copy of that paperwork, they then have to give that to the other side. So being aware of that. Another place that comes up a lot is with mental health records in civil cases. So if in a divorce case there was a reason to bring in mental health records of one of the parties, then it might also be very relevant in a criminal case and could be introduced into that case as well. And once they are out there and they're in the public records and part of a court case, they can be used in pretty much any other case, either at trial or even just in negotiating, trying to resolve things. It's kind of a leverage point for plea agreements and things like that. So that's just one thing we wanted to talk about with that. So the inconsistent information, and it can also sometimes be used against victims if it looks like they're filing something as a motive to do, they can be used against them in terms of motive. So that can come up in terms of, we had an ugly custody battle going on, and so she filed a protection order, but it was only because of the custody battle. There's not actually a safety issue. So she's only raising this issue of violence or these incidents that have happened because of the custody battle is something that we hear a lot. And, hopefully most courts can see through that, but it is also something that victims need to consider with the timing of filing things. And obviously putting safety first, and if someone needs to seek a protection order, then that they should for their own safety, but also realizing that it can be portrayed in other cases as being a negative thing. Another one with that is with immigration. They can often, I've heard often that stereotype that someone is just now bringing a protection order case or filing a criminal case to try and get a visa through the immigration process. I'm seeing a question come in here, so sorry for the pause. Do you have resources that clients could have that might want to pursue Title IX complaints? So the first step with pursuing a Title IX complaint would be to go to the university specific Title IX process and just get as much information, because each school handles it a little bit differently. After that, you can certainly contact either the VRA side of RMVLC or LINK, and we can try and refer you to some other resources around that too. I think that's it on the intersection, sorry. That was not smooth. So, go ahead, Jody.
So now we're going to talk a little bit about the Victims' Rights Act, and I don't want to spend too much time kind of going through the nitty-gritty since this isn't a VRA training, and judging by everyone's fantastic questions, you're all very familiar with the VRA, but I do want to kind of highlight a couple of points about the VRA and then kind of talk a little bit about that intersection once again and where we often see the intersection between the civil, the criminal, and kind of how the VRA plays into that. So I want to start kind of looking at the questions that you had. And so there's a few questions that I may not answer, and I may just ask that people call us just because they're a little more case specific, but we'll try to go through all of them. And so the first question was about how to promote the VRA and to ensure that jurisdictions are complying with the law, and that's a fantastic question. And often, something that people aren't exactly sure how to make sure that something isn't a VRA complaint. And I think one of the best ways to promote the VRA and ensure compliance is to know the VRA. Read it, know it, so that you can spot when a victim calls you. You can spot something that you think, that may be a VRA violation. Something else you can do if you think you're dealing with VRA violations in your cases is to call the Rocky Mountain Victim Law Center. We are state VRA experts, and so we are always happy to field calls regarding potential complaints and talk about the process if a complaint needs to be filed, and talk about, yes, that does sound like a violation of VRA, or maybe it doesn't. Let's talk about this a little more, get some more information. So, I think learning the VRA and attending trainings is obviously the best way to kind of spot those issues and promote the VRA. Once people know that you know it, it's going to obviously help with their compliance of it as well. So the next question was things about what the VRA does not cover, and we'll get to that in just a minute when we go through the crimes. So there's a question, and a great question that we get a lot is about if there's ways for a victim to opt out of a subpoena when it comes to testifying against their abuser in court. And that is an incredibly complex question that does involve some legal advice. So I'm going to skip the legal advice part of it. But I would love for whoever does have that question to give me a call, because I would like to go more in-depth into that question. I think it's a little, like I said, there's a little bit of legal advice in there, so please give me a call so we can talk about it a little more. But district attorney's offices have subpoena power, and so they can issue subpoenas to the victims to testify. And so while the victim may have to honor that subpoena, and that gets into the kind of nitty-gritty legal aspect of it, what would happen if the victim didn't honor that subpoena and show up to court, there are things, potential kind of testifying accommodations that could be made, especially when you're dealing with child victims. And sometimes that includes being able to bring a teddy bear up on the stand. I know a lot of courthouses or courts in the Denver metro area and across the state are starting to use facility dogs, so the potential for a facility dog to help through testimony. Also the potential maybe for the person who's testifying to not have to walk in after the jury is seated, but to already get to be sitting in the witness box to testify, and then to have the jury come in just to be a little less intimidating. And also courtroom tours I've found have been incredibly helpful for victims who need to testify. And what that is that the victim would go in with the district attorney and advocates and their support system prior to testifying when a courtroom is empty, and kind of get to sit in the witness stand and have the DA just ask some general questions just to get more comfortable with the process. And there's also trial preparation that DA's offices can often do, and private attorneys or support from advocates that's incredibly important to getting them through that testifying part. As to the legal aspects of that, though, please, if you ever want to discuss that more, give us a call here. I'm happy to kind of go into that in more detail. So the next question is regarding the best way to be sure that the victim's input on sentencing is heard and respected when the DA is making a plea bargain. And so I think we already talked about that a little bit, and that is that victim impact statement. Letting the judge know, I disagree with this plea, this is how I feel, this is what I want. And while the judge, if a plea offer is accepted, the judge isn't going to likely to go way outside of that sentencing range. If the judge has already accepted the plea, they're not going to be able to do that. It does give the judge the sense of what's happened to the victim and the sense of what the victim wants, and allows the victim to be able to state that to the court, where if they weren't giving that impact statement, they may never have their opinion known. And so oftentimes it's super, super helpful if there's a range, a sentencing range that's been offered, like a lower range and then a higher number of years, for the victim to really give that impact statement and state how many years they want and what they want, so the judge can look at, is this a crime that deserves the higher range of year, or the higher years in the range. So it's incredibly important, and I think the impact statement is the most important part of that. And I think something too that's incredibly important with that right to consultation is to make sure that that is being respected, so that the victim feels like they got to give the district attorney's office their opinion. Now the victim, there's the education piece of that the victim has a voice, not a veto, and the victim doesn't get to veto the district attorney's office's plea bargain, but they should have gotten to feel heard by the DA's office. And talking about that and trying to figure out what would really help the victim in this situation feel like they were heard. And oftentimes that's having a meeting with the DA's office, even after a plea is offered, so that the victim can express to the DA what their feelings are, what they wanted, and there can be that open discourse about that plea offer. And then the last question, about whether people can enlist support from law enforcement agencies other than Denver to have in-person meetings with victims. And so that one, I would also like whoever asked that great question to give me a call so we can talk a little bit more specifically about that. It's kind of probably a little jurisdictional dependent and who's investigating the case. And I'm sorry, I passed one question. So there's also a question about, as a nurse, what needs to be known to not compromise the prosecutability of a case while assessing and caring for a victim. And that is actually also a great question to call with, just because that is pretty in-depth. And the explanation of that can get into some legal kind of nitty-gritty. So if you would like that question answered, and I would love to answer and talk more about that question, please just give us a call. All right, so into the VRA a little bit. Like I said, we're not going to spend too much time going through, just because I know you all have your VRA trainings every year, so I don't want to kind of bore you with everything again if you've already had it this year or just recently had it. But one of the most important aspects of the VRA that is often overlooked in the criminal justice process is that victims' rights are to be defended in a manner that is no less vigorous than the protections afforded to criminal defendants. And so we often hear that victims say that criminal defendants' rights trump their rights and that they have no rights. And while, yes, they may have less rights, and criminal defendants' rights have been around for much, much longer, our VRA does state that the victims' rights are to be protected in a manner that is no less vigorous than protections afforded to criminal defendants. And I think that that's something that's important for victims to know, because it's important for them to know that our legislature enacted this and thinks that their rights are just as important. So that's something that I always really like to point out in the VRA, because I do think it's so incredibly important and something important in that education piece for victims to know. So just briefly, victim, since we talked a lot about victims but haven't actually defined it under the VRA. A victim is a natural person against who a crime has been perpetrated or attempted, and this is all under the Victims' Rights Act in a criminal case. Just want to go back and say that. So it's a natural person against whom any crime has been perpetrated or attempted that is not a co-defendant, so that's a really important piece of that. If the victim is deceased or incapacitated, and for the VRA, incapacitated also means someone under the age of 18, then the victim can be the person's spouse, parent, child, sibling, grandparent, grandchild, significant other, or other lawful representative. So often we see that play out in like child sex assault cases where parent is also a victim because the child is under the age of 18. So there was a question about kind of what is not included in the VRA. So here on the screen you're going to see a list of crimes that are included. It's more generalized. There is a long list. We kind of put things together just for brevity's sake. But I think one of the best ways to think about it is VRA crimes are crimes against people, and non-VRA crimes are crimes against property. So one confusing part of that often gets overlooked is that identity theft, which is pretty much a crime against a person and very invasive and destroys lives, is not a VRA crime. Although I think it should be, it's not. And so that is kind of one of those little bit of a gray area where you do kind of have a crime against a person that is not a VRA crime. But VRA crimes include crimes that result in death, assaults, any domestic violence crime, any sex offense, child abuse, crimes against at-risk persons. So if you do have a financial crime that's against an at-risk person, then it is a VRA crime. Stalking, bias-motivated crimes, witness or judge or juror tampering, intimidation, retaliation, violations of protection orders in sex assault and domestic violence cases, and human trafficking. It's kind of a brief list. Like I said, there is a very long list, but these kind of lump several of them together. But once again, the best way to kind of look at that is it a crime against a person or is it a crime against property? And then kind of go from there. And as always, if you have any questions, you're welcome to call us. So the first rule of victims' rights is the right to be treated with fairness, dignity, and respect, and to be free from intimidation, harassment, or abuse throughout the criminal justice process. So the important thing to note about the Victims' Rights Act is that it only applies in criminal cases. It does not apply in the civil cases that Cassie was talking about. So that's something incredibly important to note, and something that I think we get a lot of questions on from people who are calling who still have that confusion of what's criminal, what's civil, what's going on in the different systems, and where their rights actually lie. So the Victims' Rights Act only applies in criminal cases. So the rights that we're fixing to talk about that a victim has, including this right to fairness, respect, and dignity, is only in a criminal case. They do not have the same rights in a civil case. So next you're going to see a long list of the rights to be informed and present at all critical stages. So we've already talked about some of those. We've talked about consultation rights. We've talked about the victim impact statement. Here kind of on the list, the victim has the right to be informed and present at filing of charges or to be informed of a decision not to file charges. Preliminary hearing, arraignment, motions hearing, trial. Trial is a critical stage that the victim has a right to be present at. There are some more complicated issues around something called sequestration that's a little out of topic for us today, but if you ever do have questions regarding a victim's right to attend certain court dates, please give us a call. That's something that we do quite often deal with, and so we can kind of talk through those issues as well. So there's automatic rights where the victim doesn't have to opt in, and those are pre-sentence, mostly pre-sentence rights, and then after sentencing, so after a guilty verdict or a guilty plea, and then the judge has issued a sentence, there are opt-in rights where the victim actually has to request to receive those rights, and that's what you're going to see on the right side of the list here is the opt-in rights. The left side is the automatic rights. So the opt-in rights are to be notified about the probation revocation hearings, change of venue or transfer of probation, early termination, parole application hearings, parole, release, or discharge from imprisonment, revocation hearings, execution if it's a death penalty case. So there's kind of two different sets of rights. You have the automatic rights and then the opt-in rights, and those are listed out for you there. So you also have the right, the victim has the right to be heard in certain circumstances, and those are also listed here on the screen. The right to be heard involves hearings about the defendant's bond, and that's in certain circumstances about bond, especially if bond is going to be set at something that is the non-scheduled bond in a case. So negotiated plea agreement, and that's something that we've talked about and something that ends up being super important a lot of times, is the victim has the right to be heard about that plea agreement. Whether they disagree, whether they think it's great, whatever that whatever the victim's opinion is, the victim has the right to be heard about that, and that should be respected. But also the victim also needs to know that just because they have the right to be heard does not mean they have the right to change it. Once again, I know we've already talked about that. Once again, all these rights to be heard are criminal, not civil. So there's the right to be heard if a defendant requests a modification of the no contact provision of the mandatory protection order. And we see that quite often where defendants will want to have electronic communication with the victim, telephonic communication with the victim, or ask for the whole no contact provision to just be dismissed. So the victim has a right to be heard about that if the defendant is trying to modify the no contact provision, which says that the defendant can't have contact with the victim. Something else that's important to note about that is the victim can also request a modification of the protection order, and we see that quite often where the victim does want to have contact with the defendant. Oftentimes they'll ask for the electronic or telephonic communication or ask for that whole no contact provision to be gotten rid of. And so the victim does have that right to request the modification. That does not mean that the district attorney's office has to agree with their request for modification, nor does it mean that the judge has to agree. So if the victim does request the modification, the district attorney's office does have to tell them how to do that. But the district attorney's office can go into court and give a different opinion and say they object to the modification of the protection order, even if the victim does want that. So that's an important piece to know, and something that we see a lot is victims wanting those protection orders modified and the district attorney's office objecting to that modification. So the education piece between, and that's often a time where the district attorney's office position varies widely from the victims. So that's an important piece to pay attention to. So the next thing that we're going to talk about and kind of wrap everything back in is a subpoena for the victim's medical, mental health, education, victim compensation, or other privileged records. So Kazi already kind of talked about how mental health records in a civil case can be used in a criminal case. And so under the VRA, if in a criminal case, the victim's healthcare provider or the victim themselves or school or victim compensation receives a subpoena, it's called a subpoena ducis tecum for the records, for these records, the victim has the right to be heard on that issue, and that's something that we do a lot of here at Rocky Mountain Victim Law Center, is filing what we call motions to quash to try to prevent the court from receiving those records. So this kind of wraps back in to that civil piece, because if those records have already been turned over in a civil case, that makes it much easier for a defendant to get those records in the criminal case. So the laws around privilege and privacy in these records are incredibly strong in Colorado, but if those records have already been given up or overturned or turned over to in another case, it's much harder to say that the victim hasn't waived their privilege because those records have already been already out there. So that's kind of one of those pieces that to really monitor, especially when you're having this interplay between the criminal and the civil cases, is that our records, medical records, school records, private privileged records of the victim being turned over in a civil case. Or going back to that whole piece of the district attorney's office having to give over exculpatory information to the defense, is the victim trying to turn those records over to the district attorney's office. In Colorado, the defendant has to prove that the victim has waived their privilege to those records in order to get them. So if the victim has turned those over to the district attorney's office, or if law enforcement has the victim sign a waiver for those privileged records, then the defendant has a much easier time getting those records. So there's all sorts of interplay in that issue, and it's something, like I said, that we do a lot of, and you're always welcome to call us with questions regarding that. But just know that once those records are turned over, it's much harder to unring that bell than it is if those records were never turned over. So we always want to caution records being turned over in civil cases when there's a concurrent criminal case, or conversely, records being given to the DA's office, or waivers being signed for especially therapy records and things of that nature, law enforcement having those waivers signed and then those records being given to law enforcement, because then they then have to go to the defense.
And that's really the bulk of our content today. I know that was a ton of information to share about a lot of different topics. I do have a couple other questions noted that I will talk about now that people will send in with their registration. But if you have any other questions now that you want to just type into the question box, we can try and answer some of those. Again, not if it's super case specific. We prefer to do those kind of offline. But if there's just general questions about anything we talked about, go ahead and type it into the question box. I did get a couple questions about resources and supports for victims with intellectual or developmental disabilities. I'm glad that was brought up. That could be a whole entirely separate training and should be, but there are definitely supports needed, particularly for people in either the criminal or civil legal system who have intellectual and developmental disabilities. And there are a few organizations that do an outstanding job with that. The ARCs in the different counties, ARC of Aurora, there's El Paso County also has an ARC, do a great job with advocacy around that. Advocacy Denver in Denver also specifically works with that population and is pretty well equipped and savvy at helping provide support through the court system. It's definitely more common for people who have any disability to be victimized, and so making sure that there are additional supports around that is important. Disability Law Center, in terms of legal rights around ADA and other accommodations, is also another resource that you could look at for that. There was also a question about what civil rights issues and remedies crime victims face, which is a much bigger, broader question. Civil rights issues can be anything that can relate to how police interact with people, how the courts interact with people, how other government agencies interact with people, and it falls kind of under that, that vague gray area of administrative law again. But in Colorado, we're fortunate to have a strong statute for the Victim Rights Act in the criminal cases, so that there are a lot of very specific protections for victims in cases. And even though the VRA doesn't apply to civil cases, there are just general protections for parties in cases around privacy interests also. So I know that's a little different than the scope of this question, but in a civil case, if there was a subpoena for records, it has to be shown that that is relevant to the case. So if someone files a civil case against their landlord or a neighbor or a business partner or something like that, you can't then just go in and ask a subpoena for all their mental health and medical records. It has to actually relate to what's happened. However, if I fall down and break my leg on Jody's front lawn, then I can she can actually do a subpoena to ask for all my medical records to show that that's actually how I broke my leg and that I didn't have a broken leg before I stepped onto her property, things like that. So there are some privacy protections just around rules of evidence in civil cases that things have to be relevant to the matter, but it's not like the strong protections to privacy that the VRA does offer in a lot of situations. I am not seeing any other questions pop up in the box. So if that's all you all have, I want to thank you for going through the webinar. Here's our contact information, the main number for Rocky Mountain Victim Law Center, also the website for RMVLC and for LINK. And on the LINK website, you can find a lot of legal information and resources on both civil and criminal areas of law. It was a website designed to get accurate and reliable legal information to victims of crime. So feel free to peruse that to answer some questions as well. And if you have specific case questions, civil or criminal, feel free to reach out to us. We'd be happy to answer them as much as we can. And do keep your eyes open for additional trainings and 2 additional webinars that we're going to be able to do through CICASA. Also some presentations at the conference this summer or this spring, and also some additional training opportunities through LINK that will be coming up in the next couple months as well. So, and if that's it, no further questions, we will go ahead and close out today a little bit early.
Thank you.
Thank you.
Thank you so much, Casey and Jody. Sorry, I work with another person that is Casey. I would also like to thank you all for participating today. And as Jody and Casey mentioned it, we hope that you will join us in 2 weeks on February 15, around 12 noon for the next webinar, because as like they mentioned, this is a series of 3 webinars. The next one will be about privacy and safety. So please also fill out our survey at the end of this webinar, and we look forward to see you or meet with you next time. Have a wonderful day. Thank you so much, ladies.
Thank you.